Hello, welcome to this recording on online speech and the criminal law. I shall introduce myself first. My name is Patrick Bishop. I'm a senior lecturer and head of undergraduate admissions at the Hilary Rodham Clinton School of Law at Swansea University. And the purpose of today's recording, podcast, vodcast, whatever you would want to call it, is to give aspiring law students who might have some time over the summer vacation an insight into the sorts of subjects you would study as an undergraduate law student. So as you can see from the title, as I've already mentioned, what we will look at today is online speech and the criminal law. Now this is a topic that spans various modules that you could study on the LLB at Swansea and in most law schools within the UK. And obviously one of those subjects would be the criminal law, but this would be a very niche area of criminal law. It wouldn't be something that you would usually consider as part of a criminal law module where you would look at things like murder, manslaughter, theft, etc. But nevertheless, it is criminal law, albeit niche area of criminal law. At Swansea, I teach. I'm the module coordinator for the cybercrime module, and I teach online speech and the criminal law as part of that module. But equally it could be taught in some universities as part of a media law module, even an information technology law module, etc. So that's what we plan to talk about today. So we'll look at some law, look at a particular case, and then towards the end then we'll engage in the process that you would engage in almost on a daily basis as a law student. Have a go at tackling an exam question, formal exam question on this topic, and discuss the issues that raises, etc. So before we look at the actual law, I thought it would be useful to place this discussion in some context. And so our focus today is particularly on online communications. And in this context, we could look at a concept created by an academic called John Suler called the online disinhibition effect. Now, as the picture illustrates there, a common mantra that you hear in cybercrime and malicious communications, etc., is that if something's acceptable offline, if you wouldn't do something offline, then you shouldn't do it online. It's not acceptable online. And this is used in lots of different contexts. So, for example, copyright infringement, for example, the argument often made is if you wouldn't steal a DVD from a shop, you shouldn't illegally download a film from the internet. And so what John Suler was trying to do was to consider the internet and to consider whether there's something about the internet which makes us lose our inhibitions, hence the online disinhibition effect. Now, of course, anecdotally, I'm sure we all know people who might be given the title keyboard warriors, individuals who are very placid, polite, mild-mannered in the offline world, but are the exact opposite via email, instant messaging, etc. So it's interesting to consider then why we some of us at least lose our inhibitions when we're communicating online. And so Suler, in his article on the online disinhibition effect, has pointed to a number of features of online communication which enhances this disinhibition effect. I've just picked 4 here just for illustrative purposes. It's slightly more involved than the infographic suggests here, but just picked 4 for the purposes of illustration. So the first is anonymity. Now this is a particular problem in cybercrime more generally, this idea that the internet affords criminals the luxury of anonymity. You can hide your identity, etc. So even if you are aware that there might be legal consequences to expressing a certain opinion or using a certain form of words online, you might well reach the conclusion, well, because you were communicating anonymously, okay, you might have a username to participate in a discussion board or to post on social media, etc. But obviously there's no guarantee that that username or the details you provided is any way accurate. So this idea that because we feel that there's fewer consequences to our actions online, that might lead to this inhibition, or might lead to reduced inhibitions. So the second aspect then is what Sula calls asynchronous communication. So what we mean by that is when we communicated in the offline world, if we're having a conversation, for example, or even a telephone conversation with someone, then the communication is synchronous in the sense that you say something, you can gauge someone's reaction straight away. If they find it upsetting or offensive, they can tell you, or you can gauge that they find it that way via their body language, how they react, etc. And so we get this instant feedback in face-to-face offline communications. Now that can happen sometimes in online communications. You might upload a tweet and within a few minutes there's numerous replies, etc. But in other forms it's not always the case. So you might send an email to someone and then log off, so you don't receive their response for a while. You might post something on social media and then put down your phone and not look at it again that evening, and so you won't receive the replies, the reactions, etc. So the response that we get from our communications is delayed, and that, again, according to Sula, can have this disinhibition effect, because we don't see the immediate consequences of our speech, of what we say. Then that leads us to be more relaxed in terms of what we say. And then on the one on the bottom right, then, disassociative imagination. Quite a complex title, but essentially what Sula's talking about here is this idea that some people see cyberspace as a game, as it were. So you can create a new identity, a new persona for yourself online, and it's been suggested that people, when they are online, see that as a different world, as it was, a game almost, and therefore the normal rules do not apply. So it's almost as if, well, I didn't actually say that, it was my online persona said that, and that's the psychological effect that the online world and how you communicate online can have. And then finally, minimization of status and authority. So again, in the offline world, people of high status and authority will often have symbols which demonstrate that. The way they wear, the clothes they wear, their body language. If you're a high-ranking politician, the security guards around you, etc. Of course, in an online world, it's not obvious that someone has that high status and authority. And again, that can lead to this disinhibition effect. And that's borne out really anecdotally. If you look at communications online, where no matter how high an individual's status is, they can still be the subject of considerable criticism, vitriol, offensive communication online, etc. So there's some examples of an effect that I'm sure most of us have experienced at one time or other in our lives. This idea that people tend to be more less inhibited online than they are in the real world. So in terms then of the impact of online abuse, of course it's maybe not in the same category as physical abuse, as offences like murder, manslaughter, assault, battery, etc. But it is a very, very serious issue. So the top snippet there, harm caused by online abuse, that is taken from a Law Commission scoping document published last year, which has highlighted some areas where the law on online abuse and online communications could be reformed. And I won't go through it because you can pause the video or read it as you go along. But essentially it makes the point that this is very much a very serious issue, and they've pointed there to examples of people actually committing suicide, having become the target of abusive and offensive online communications. Because one of the problems with this area of law is not everyone reacts to that in the same way. So with sort of physical harm, if you like, that's easy to determine. If you hit someone with a baseball bat, it doesn't really matter who that person is or what their characteristics are, they will suffer injury. Of course, because we're talking here about psychiatric injury, excuse me, then it's not quite straightforward to draw that clear link between the speech and the harm. So they say, for example, in the second paragraph, some people find different tweets, for example, threatening others, will simply dismiss it. But the most common reaction is annoyance and anger. So some people who may be particularly thick-skinned would just laugh a comment off or take no notice of it, whereas others who might be more sensitive it will have a very big impact on their psychological health. So that's one of the problems. It's not universally harmful. A particular statement is not universally harmful to everyone who reads it in the same particular way. Just give you some other examples. So we made the point about the lack of status and power symbols online. I think a classic example of it is the way that MPs, particularly female MPs, are the victims of online abuse on Twitter and other social media platforms. So the example they're taken from a newspaper from The Guardian is Diane Abbott, but apparently it's a very common problem amongst particularly female MPs, this constant abuse, etc. that takes place online. And that was even linked to the last general election. Number of female MPs who were at relatively early stages of their career decided not to stand again for election, and many of them cited the abuse that they received online. And obviously engaging in genuine and legitimate public debate is important, and I'm sure no MP would be critical of someone who constructively criticised or engaged with the policies that they advocated. But many of the comments that MPs are subjected to go well beyond that, including death threats, threats of rape, other sexual violence, comments on their appearance, very cruel comments on their appearance, etc. So, of course, it's not just limited to MPs and people in position of power. Particularly young children can feel the impact of online abuse very, very keenly. And it is a particular problem amongst young children. And then finally, the last one, a fairly topical story, Caroline Flack, who tragically took her own life. There's a lot of discussion after the suicide about the effect that the media had on that, social media, etc. And this idea that social media is a place where cruelty prevails. So the basic point is, I think that this is a real problem. Of course, not everyone responds to a tweet or a message on social media in the same way, but for many, many people and in many instances, this is a very, very serious issue. And of course, whenever we have a serious issue in society, something which causes harm, then the very common response of Parliament is to step in with the criminal law as a very clear signal to society as a whole that certain conduct is wrong and, if committed, might potentially lead to punishment. So in terms then of the criminal law and how it might combat online abuse, etc., there's quite a large range of different offences which are available. And so on this slide, I'll just give you a very, very brief overview of some of the offences which are available, but then we'll focus on an offence which isn't on this slide under the Communications Act. So the starting point then will be the Public Order Act, and under Section 4 there's numerous offences which use very similar wording, but it's generally an offence to use threatening, abusive or insulting words. And even though the term public order is used, without going into the technicalities for the purposes of this recording, in order to avoid this recording being too long, even though it's about public order, it has been, such offences as Section 4 has been applied to online communications. So then we have also the Malicious Communications Act 1988, a fairly analogue type offence. What I mean by that as an offence, it was primarily designed, actually goes back a long way. The 1988 version is simply the latest manifestation. What I mean by an analogue offence is an offence that was primarily designed to deal with the offline world. So, for example, under the Section 1 offence, it's the offence of sending a letter with intent to cause distress or anxiety. Although in later amendments to the Act, email was added as an addition to the offence, but it was primarily, at least in the before the digital revolution, seen as an offence related to the post office and the sending of letters, etc. Then we have the Protection from Harassment Act, 1997. So this was an act that was passed at the time following public concern and government concern about the problem of stalking. And under Section 2, there's an offence of engaging in harassing conduct. Now, one of the limitations of the Harassment Act, or Protection from Harassment Act, is that you need to, in order to demonstrate an offence has been committed, you need to show that the defendant has engaged in harassing conduct on more than one occasion. And that's referred to as a course of conduct. So whereas under the Public Order Act 1986, a single tweet, a single message can be an offence, so is the case with a single email under the Malicious Communication Act. Under the Protection from Harassment Act, you need this course of conduct. So a single tweet, a single email, a single post on social media, etc., wouldn't meet that requirement. And the rationale of that approach under the Protection from Harassment Act is that if something happens once, we are more likely to not be overly concerned by it, to dismiss it as an irrelevance. If something is repeated, it suddenly starts to take on a more sinister tone. To give you an example, you receive a phone call, you answer the phone, and it's silence at the other end. So if that happened once, you would just think it was someone, a failed marketing call, someone trying to sell you PPI insurance, etc. If that happened 3 or 4 times, 5 times, 6 times that day, then it would suddenly take on a far more sinister undertone, and you might start to become concerned. So the rationale of this course of conduct requirement is that something may not be particularly worrying, concerning, might not cause anxiety if done once, but if repeated, suddenly takes on a more sinister undertone. But anyway, it is potentially capable of combating online communications, but as I said, as long as it meets that course of conduct requirement. And then finally, before we focus on the Communications Act, we have the Terrorism Act 2006, and in particular Section 1, which is the offence of encouragement of terrorism. So it's any sort of communication, speech, writing, etc., which encourages acts of terrorism, etc. And obviously since 9/11, since September 11th, 2001, a number of terrorist offences have proliferated considerably in English law. So it's a very specific one, but obviously it's still a communication offence because it would be applied to, for example, terrorist propaganda published by the Islamic State, so-called Islamic State, or Al-Qaeda, etc. So there's a fairly wide range of criminal offences which can be used to combat offensive communications online. But as I said, we will focus on one particular offence. So the offence under Section 127 of the Communications Act is essentially an offence which can be committed in one of 2 main ways. So the first on the right, as you look at it, the blue circle, the offence can be committed by sending a false message which the defendant knows to be false, and that message was sent for the purpose of causing annoyance, inconvenience, or needless anxiety. So this is quite a specific offence. So first of all, you have to show that the message is false, and you also have to prove that the purpose in sending the message was causing annoyance, inconvenience, or needless anxiety. So a example of that might be you send a message to someone telling them their partner, their husband or wife, or boyfriend, girlfriend, etc., has been involved in a serious car accident and has either died or is very seriously ill. Now, if that's false, and you do that via an electronic communications network such as the internet or social media, then that might trigger Section 127. And even though you have the obligation as the prosecution to prove that there was an intention to cause annoyance, inconvenience, or needless anxiety, in many cases such as that, the facts will speak for themselves, in that it can automatically be assumed that you sent the message with that purpose. Or to put the question another way, what other possible purpose could you have in sending a message like that to a particular individual? So that's the first variant of the Section 127 offence. The second and more common and more flexible version of the 127 offence is sending a message that is grossly offensive or is of an indecent, obscene or menacing character. So the key point, one of the key words here is the repeated use of or, and so that means that these are alternatives. So in order to be guilty of an offence under Section 127, one, you don't have to prove that the message is grossly offensive, is indecent, obscene or is menacing. They are alternatives. In some cases the test is one of gross offensiveness. In others it might be an obscene or indecent message, for example involving pornography, and others might involve a menacing message such as one involving a threat, etc. So essentially then you might say there's actually 4 different versions of the Section 127 offence. There's a message which is grossly offensive, one which is indecent and obscene, one which is menacing, and finally one which is false and the defendant knows it to be false, etc. And then in the middle, the reddish colour circle underneath, the act is limited, or the Section 127 offence is limited to a message sent via a public electronic communications network. So what that essentially means is a network which is provided for the purposes of making electronic communication services available to members of the public. So don't be confused by the use of the word public here. We don't mean publicly owned as you would use in the sense of the public sector. What we mean is simply a communication system which is available to the public. And of course the internet is perhaps the archetypal example of a public electronic communications network. So for example, if I sent a message in an internal system, so for instance if I used an intranet platform, intranet as opposed to internet, so it was only sent to other members of a particular organisation, then it wouldn't be caught by the Section 127 offence. The message wouldn't be caught by the Section 127 offence because that wouldn't be a public electronic communications network. We don't need to get overly concerned with the technicalities here. I think for today's purposes it's more than enough to say that basically the Communications Act and the specific offence in Section 127 would apply to internet online communications. So as I've said, the main focus of today's discussion is a particular variant of the Section 127 offence, and as an offence which involves sending a message which is grossly offensive. Although in the essay question towards the end we will also look at another variant of the Section 127 offence, an indecent or obscene message. So apologies from here on in, there's very little if any photographs used in the slide. As you'll see from the subject matter, it's very difficult to represent the facts and the decision of this case via the medium of pictures. So what happened in DPP against Collins? A fairly straightforward set of facts. So Mr. Collins had, over the course of a significant period, over the course of more than 2 years, he telephoned his MP's constituency office, and in the case report, it somewhat euphemistically says that Mr. Collins held what was referred to as strong views on immigration. So he would speak to whoever answered the phone, either the MP himself or more commonly members of staff who worked in the MP's office, and if he didn't get an answer, he would leave a voicemail. Now, during these calls and voicemails, the defender, Mr. Collins, routinely used racially offensive language. And I won't say what that language is here, because I don't want to offend anyone, but trust me, it's all the language you would expect to hear from someone who essentially was a racist. If he wasn't a racist, he certainly used extreme racist language. So he was charged with sending messages that were grossly offensive. And so the gross offensive type of offence is probably the most flexible. So indecent or obscene would usually involve some form of pornographic content. A menacing message would usually involve some sort of threat. And so grossly offensive is far broader, can include anything as long as it passes that grossly offensive threshold. Now, of course, you might have something which is pornographic and grossly offensive. You might have something which is a threat and grossly offensive. So there can be some overlap, but this concept of gross offensiveness is I think, the most flexible of the three variants. So anyway, he was charged with the offence under section 127(1), and the Magistrates' Court acquitted the claimant on the basis that a reasonable person would consider the messages offensive, but not grossly so. So the key word in here is important. It's not an offence to send an offensive message. It's only an offence to send one which is grossly offensive. So obviously that is a higher test. That's a stricter, higher threshold to cross. Now the Administrative Court of the High Court upheld the acquittal, and the Director of Public Prosecutions, the head of the Crown Prosecution Service, appealed to the House of Lords. Now, generally speaking, if there's an acquittal, particularly in the Crown Court where the acquittal is by a jury, then the prosecution, as it were, are not usually permitted to appeal against that. If you're acquitted by a jury, then that acquittal cannot be interfered with. But where the first decision is made by a magistrate's court, then it is possible to appeal against an acquittal. And that is essentially what happened here. As I said, it eventually found its way to at the time, the highest court in the land, the House of Lords. The House of Lords was the highest court in the land for centuries in English law, and was replaced by the Supreme Court some years ago. But it's essentially the same court. So that was the facts then, and basically the House of Lords had to consider whether Mr. Collins should have been acquitted. And in deciding the case, the court, the House of Lords, started first of all with the rationale of section 127. And basically they started off by discussing what the rationale isn't, and it isn't to protect users from unsolicited offensive messages. So they said the system isn't designed to protect individuals, you or I or any other user of a public electronic system, from receiving unsolicited messages which we find offensive. It is designed, or the purpose, is to protect the communication system itself. So according to the House of Lords, the offence is there to protect the public electronic communication system and not users of the system. And that's a very important distinction, which, as we shall see, has led to an incredibly broad offence. So in terms then of the actus reus, so for those who don't know, the actus reus of an offence is the sort of acts that you need to engage in order to commit an offence. So, for example, the actus reus of murder is killing another human being. The actus reus of theft is permanently depriving someone of property, etc. So it's the physical act, if you like, or the action part of the offence that needs to be satisfied. And here the court said the actus reus was simply sending a message regardless of whether it was received. Now, it did not matter whether or not the person receiving the message was offended. Now, this is important because in both the Magistrates' Court and the Divisional Court of the High Court, the judges in those cases, in those hearings, were influenced and emphasised the fact that the MP himself was not from an ethnic minority, and nor were any members of his staff. So none of his staff were from a BME background. And so the court concluded that, therefore, while some of the staff who listened to the message might be offended, they weren't grossly offended. And the court concluded, particularly the divisional court, that the word grossly was inserted so that the offence interfered with as little as possible with freedom of speech. So obviously in a democratic country such as the UK, freedom of speech, freedom of expression is hugely important. It's often seen as the sort of bedrock of democracy. And in terms then of the European Court of Human Rights, and the European Convention on Human Rights guarantees freedom of expression via Article 10, the courts have always said that the right to freedom of speech or freedom of expression includes the right to offend people, the right to insult people, etc. Particularly in Britain, it's seen as a great British tradition to be able to insult another person without fear of legal challenge, and long may that continue. So the Divisional Court said that the word grossly was added to make sure that the offence, or try to ensure the offence restricted in as little as possible freedom of expression. And according to both the Magistrates' Court and the Divisional Courts, while these messages were offensive, yes, they did not cross the threshold of gross offence, and therefore no criminal offence was committed. And as I said, they placed particular emphasis on the fact that no members of the MP staff were from a black or minority ethnic background. And so the House of Lords took a very different view, and they said because the rationale of the offence, the purpose of the offence is designed to protect the system itself, the internet or the communication system itself, it didn't matter that the person who received it wasn't offended. It didn't matter even if they didn't receive it, because by using the communication system for the purpose of sending a grossly offensive message, you've undermined the integrity of the system. And there was some discussion in the case about what would happen if there was a script editor and a director working on a film, if they sent scripts back and forth to each other via email, and those scripts contained racially offensive language. You think pick a Quentin Tarantino film, for example. They considered whether that would be an offence. And on the interpretation of Section 127, that possibly would be. So as I said, that rationale creates a very broad offence indeed. So then the court went on to consider that whether a message is grossly offensive is determined by applying the standards of an open and just multiracial society. So it's an objective test, and that means it's not based on whether the defendant thought the message was grossly offensive. It's not based on whether the recipient of the message thought it was grossly offensive. The test is based on the standards of the open and just multiracial society. So it's an objective test. And then in terms of mens rea, so we've already discussed actus rea. So what do we mean by mens rea? Well, the mens rea is the mental state, or the state of mind, if you like, that you have to possess when engaged in the actus reus in order to complete the offence in question. So I used murder as an example in illustrating the actus reus, so I'll continue that with the mens rea. So the mens rea, the mental state required for murder, is an intention to kill or to commit GBH. The mens rea of theft is dishonesty and an intention to permanently deprive someone of their property. So most criminal offences outside of what we call strict liability offences, which are very rare, most criminal offences will have both of these elements. You have to show the actus reus in conjunction with the mens rea. Now this particular offence, section 127, doesn't actually mention any what you might call mens rea words. It doesn't use the words like carelessly, intentionally, recklessly, knowingly, all words which indicate a certain state of mind. And the court then had to consider whether they should use or imply a mens rea requirement, and concluded that they should. Generally speaking, offences which can be committed via strict liability without a particular mental element tend to be very low level sort of regulatory offences, if you like. So failing to submit a certain report to a regulatory agency, for example, would be one example of that. So anyway, the court created, if you like, a mens rea requirement and said that the defendant must have intended the words to be grossly offensive. So that's one alternative. You intend the words you use to be grossly offensive, or you may be aware that they might be taken to be so. So if you're a fervent racist, for example, you might not find the words themselves to be offensive, but surely most people will be aware that they might be taken to be offensive. So that was the mens rea requirement, that the defendant must have intended the words to be grossly offensive or be aware that they might be grossly offensive. So the approach to the House of Lords, and as I said, was a very, very expansive one. The rationale of the offence is very broad. Whether the message was received is irrelevant. It doesn't matter if the person receiving the message was not offended or was offended. And as I said, the mens rea itself is fairly broad. You either intend the words to be grossly offended or be aware that they would be grossly offensive. So having considered all those issues, the House of Lords allowed the appeal, which essentially means in sort of common usage that the DPP won. The person who applies for the appeal is called the appellant. The person who argues against the appeal is called the respondent. And so when the appellant is successful, the courts would use the phrase that the appeal is allowed. If the respondent was successful, then the appeal is denied. So the conclusion of the court was that Mr. Collins should have been convicted, that both the Magistrates' Court and the Divisional Court of the High Court had basically misapplied the law, and therefore Mr. Collins should have been convicted. But no further order was made. The DPP, when he applied for and was given leave to appeal to the House of Lords, gave an undertaking that no further order would be sought. What we mean by that is that the case wasn't remitted back to the Magistrates' Court for retrial. This appeal was taken forward by the DPP simply to gain clarification on the law, because once the House of Lords, or in modern context the Supreme Court, has given a ruling on a particular area of law, that's generally seen as a very definitive judgment on that area of law, because the Supreme Court is obviously the highest court in the legal system in England and Wales. So that was Mr. Collins' very good luck. The court concluded he should have been convicted of an offence, but didn't remit the matter back to trial to the Magistrates' Court. So that's the decision in Collins, and you might want to think about what your own particular view of it is. And so in that light then I thought we'd engage in some further discussion. Well, not discussion in the true sense of the word, because the nature of this recording, but I thought I'd just give you an idea of the sort of essay question you might encounter during seminar discussions, during examination, dealing with this topic. And it's simply a quote then from one of the local lords in the case, Lord Brown. And I'll read the quote. It says, "I confess that it did not at once strike me that such a telephone conversation would involve both participants in committing a criminal offence." Now, the telephone conversation Lord Brown is talking about is two racists talking to each other on a telephone. So the argument was, or the issue that was addressed in this issue was, well, if you have one racist talking to another racist, is that an offence? Because neither of them will be subjectively grossly offended because they share the views. And Lord Brown said, well, at first he didn't think that would involve the commission of an offence, but he has been convinced that is the case. Or I've taken that part from the dictum here, but he was in agreement that was the case. So he says, quite where that leaves telephone chat lines, the very essence of which might be thought involve the sending of indecent or obscene messages, such as also prescribed by section 127, was not explored before your lordships and can be left for another day. So what's Lord Brown talking about here? Well, first of all, I think he's used the phrase chat line somewhat euphemistically. What he's referring to is telephone or more and more, I suspect these days, online sex lines, where you can, for the payment of a fee, engage in explicit sexual dialogue, watch someone on a webcam, etc. Now, obviously, if that's done via telephone or via the internet, then that would trigger the offence because it's committed. The act is committed via a public electronic communications network. And here he's not specifically talking about grossly offensive messages, but the other variant, or one of the other variants of the section 127 offence, sending a message which is indecent or obscene. Now, indecent or obscene would usually involve some form of pornographic content, some sort of sexual nudity, etc. And of course, they are also prescribed. Prescribed is just a technical term for meaning prohibited. So it's also an offence to send one of those messages via a public electronic communications network. And basically, the suggestion by Lord Brown here is that people who engage in that, or a person who engages in a sexually explicit dialogue with someone who sells access to their webcam, etc., is actually committing an offence. Because remember, it doesn't matter that both parties are willing participants. The offence, the rationale of the offence is to protect the system itself. It doesn't matter that either user might not find the words used or the messages to be indecent or obscene. It might still be an offence. Now, of course, you might say, well, there's a mens rea requirement created in Collins that you intend to send a message which is grossly offensive. But if you use the same mens rea, and of course you would, if you use the one mens rea for one variant of the offence, you would use the same mens rea for other variants, then that doesn't help, because clearly the very purpose of engaging in these chat lines or live webcam sessions, etc., is to engage in this sort of dialogue. And in a classic English judicial fashion, he said that can be left for another day. So this is something that you'll encounter in studying the law. The courts will deal with a particular issue before them and will sometimes accept that the way they've decided a particular case might have consequences which go well beyond that particular case, but they simply fudge the issue by either expressing no particular view on it and using phrases as Lord Brown did here, that can be left for another day. So Lord Brown has realised that the decision is very broad and have consequences beyond simply combating people who send racist messages, but has essentially fudged the issue by saying it can be left for another day. So we're asked to discuss that and what we think about that. You know, and essentially I think your view of that position will be dependent on your view of freedom of expression and how important you consider that to be, etc. Of course, the argument that's often used with freedom of expression is that while you might agree that a certain form of speech isn't justified and you wouldn't particularly lose anything by prohibiting that type of speech, the so-called slippery slope argument is often used, and once you start criminalising and preventing certain forms of speech, then that's a slippery slope, and you go down the road of prohibiting, of criminalising more and more forms of speech, which is obviously very dangerous from a freedom of speech democratic perspective, particularly in this hypothetical scenario where you could argue that there's no obvious harm created by two individuals engaging in a chat line. Now that's debatable, but we don't have time to engage in that debate. But there's certainly no obvious harm in the same way of that there would be in listening to very offensive, racist comments, etc. So one of the things you could discuss here is really the what is sometimes a disconnect between the law as it appears in the case reports and how the law would actually be applied in the so-called real world. Although of course what goes on in the Supreme Court, what goes on in law schools is the real world. But what I mean is at the sort of the coal face of the legal system. So let's just imagine there was this situation. So you had two individuals who were engaged in sexually explicit dialogue which passed the threshold of indecent or obscene, and they were both consenting adults, and they were actually prosecuted. Well, the first thing to note is that is an incredibly implausible situation, because while the offence doesn't require that a party was offended by the statement, so if one racist sends a racist message to another racist, it doesn't matter that neither was offended. But of course, in practical terms, if neither party was offended, then who will complain about it? So Mr. Collins was prosecuted because the MP himself passed on information to the police. Now, in a situation where you have two racists, or in this case two chatline users, if they're both consenting adults, if they willingly participate in such dialogue, whether it be grossly offensive dialogue or obscene dialogue, if they are willing participants, they're unlikely to complain about it to the police. So even though theoretically they could be prosecuted, in practical terms it's highly, highly unlikely, because it's only really when one of the participants actually finds the message to be grossly offensive or indecent or obscene and therefore objectionable that the matter will ever be heard or come to the attention of the police. If for whatever reason it did come to the attention of the police, then we also then have this concept of prosecutorial discretion. So not all criminal activity, even when reported to the police, by a long way, not all criminal activity actually leads to a prosecution. And in this instance, you could argue that prosecutorial discretion on the part of the Crown Prosecution Service would dictate that no offence was prosecuted here on the basis that we have two consenting adults, etc. Because even if there was a prosecution, then the defendants could clearly raise issues based on human rights. So not only do we have the human right of freedom of expression, but we also have another human right of privacy. And on the basis that usually if you engage in explicit and indecent dialogue on a chat line, you tend to do so in the privacy of your own home. So even if there was a prosecution, then I think that you could advance quite strong arguments based on human rights, based on the idea that both parties are consenting adults, etc. And the Crown Prosecution Service has acknowledged this in their prosecution guidelines on this offence, and has explicitly mentioned the dangers to freedom of speech, and said that only in extreme cases should a prosecution be launched. So the reason I mention that is there is sometimes this disconnect between how an offence can operate in theory. As I said, in theory, Section 127 is an incredibly broad offence. In practice, for the reasons I've said, it's likely to not operate in such a broad brush fashion for the reasons that I've highlighted. So if you've made it this far, thank you for listening. And if you have any questions, then feel free to email me. You can either Google Patrick Bishop, Swansea Law, and you'll be taken to my staff profile on the Swansea University website, and click on the link to my email, or you can just drop me an email at p.bishop@swansea.ac.uk. So Goodbye and thanks for listening.